Hi, yes, I'm a prior client for Mr. Davis, and I'm just here to talk about my prior case with Los Angeles DCFS. I was really jammed up with those people for false accusations and making me look like a bad parent. And I actually got my child removed for just some false accusations. I had to go online and hire the best attorney to get my kids back because they're number one to me. So I tried to go to the best lawyer I could find, and I actually did find him, and that's Mr. Davis. As soon as I went with him to his first visit, he made me feel a lot more comfortable, made me feel better. Actually gave me some fundamentals as far as what to do and what to say when the social workers are in front of your door. He made me feel a lot better, like I keep saying. He gave me some good advice. He actually got my kid back on the first court date, which I thought it was going to be impossible, which was a slam dunk for us, me and Davis.
Good morning. This is Attorney Vince Davis, and these are my office hours. I'm here with my co-host, Miss G. She's disappeared from the screen. But today, our topic is going to be what to do if reunification services are terminated in California CPS cases. Miss G, good morning. How are you?
I'm good. How are you? Good morning.
Good morning. So I understand you have some questions for me on this topic. So go ahead and start.
What does it actually mean when the court terminates a parent's reunification services?
Well, it means the court has decided the parent has not made enough progress and will no longer be offered services to reunify with their child. The case now shifts towards permanency, meaning placing the child out of the parent's care permanently. And that often leads to adoption, maybe long-term foster care or legal guardianship, unless the parent acts quickly.
Makes sense. Is that the end of the case, though, when this happens?
No, not at all. Not always. It's a turning point, though. It's a significant turning point, but it's not necessarily the end. The parents still have rights, and if they move fast, there are many legal options to stay in the fight.
Why does the court decide to terminate reunification services?
Well, it's the law. The court considers whether you've made substantial progress, quote unquote, on your case plan. And that's the case plan that the court ordered at the disposition hearing. If they believe you failed to comply, missed visits, didn't complete your services, or the child is still at risk, they'll terminate your reunification services.
Oh. Can CPS influence the judge's decision?
Absolutely.
Yep.
Absolutely. The court often relies heavily on the social worker's reports. That's why documentation and rebuttals are so critical leading up to this point. And I think I told you something yesterday on yesterday's show that I don't think you realized before, that the law requires the judge to consider and accept into evidence the social worker's reports.
Oh my God. Yeah.
So the judge following the law doesn't have any choice. The judge must do that.
That is crazy. That's why they say they have the upper hand.
Absolutely. Absolutely. So you could either complain about it or come up with a strategy to be about it.
Okay, got it. What do most parents, in your opinion, feel at this moment when,
When they lose their reunification services.
yeah,
Most feel like it's over. A lot of people give up. They give up, unfortunately, on their children. They feel panic, guilt, helplessness. But I always say, don't grieve. Instead, do something, act.
right,
Time is now your biggest enemy. You can still fight back. Many times people call you and call me, the week before or 2 days before their parental rights are going to be terminated.
right.
Had they called me 120 days before,
Mm-hmm.
I could do something. But the longer you wait, the less I can do.
What's the biggest mistake parents make after they hear this decision? Termination of parental rights.
The termination of their reunification services.
Reunification service, sorry. Yeah.
The biggest mistake they make is they disappear or give up. That plays right into CPS's hands. What you do in the next 7 to 30 days is everything in the case.
Makes sense. What are the legal remedies available to a parent after reunification terminated?
Well, most people and attorneys think of filing the 388 petition,
Mm-hmm.
a request to have your services reinstated. You can also, quote unquote, appeal the court's decision if it was based upon flawed reasoning or a misinterpretation of the law or legal error.
Wow.
Importantly, if the court terminated your reunification services and set a 2-6 hearing, you must file a notice of intent to file a writ. That's how you preserve your right to challenge the court's decision to terminate your family reunification services. The other thing you have to start thinking about is having your attorney file a motion or a request for a bonding study for the 2-6 hearing.
In Europe, can you explain to us what is a notice of intent to file a writ and how does it work? Because a lot of people don't understand that.
A lot of attorneys don't understand that.
I know that.
So, a notice of intent to file a writ, it's a specific appellate document that must be filed very quickly, typically within 7 days after the court sets a 2-6 hearing, after the court terminates your family reunification services.
Right.
If you miss that period, you're out of luck as far as contesting the court terminating your reunification services. That notice that you file, I think it's 1 or 2 pages long, it's just a form. It tells the Court of Appeal and the trial court, that you intend to challenge the decision to terminate your reunification services. If you miss that deadline, your right to challenge or appeal that decision may be gone forever.
When should a parent file that 388 petition exactly?
Well, it's a very strategic question. It's different from case to case, but as soon as you can demonstrate a change in circumstances, like completing a program, securing housing, or proving consistent visitation, cleaning, testing clean consistently from your drug tests. But that's something that you should talk to your attorney about, strategize, come up with a plan. Don't do things haphazardly.
Well, I honestly want to tell everyone out there that if you're watching right now and services were just terminated in your case, drop a comment right now, and Vincent will address those parents today, okay? So I'm letting you guys know right now, just drop your comments or questions right now, please.
Drop your comments, call me. We file 388 petitions and appellate writs across California. If you're on the brink of having a 2-6 hearing to have your rights terminated, you have no time to waste.
Mm-mm. No, you don't. And most of you guys know how to get a hold of me. Just call the 888 number and ask for me, or you can call me directly. Let's see. What exactly does a 388 petition ask the court to do?
It asks the judge on the case to reverse a previous order he or she has made, and, for example, to reinstate reunification services. If you can show changed circumstances and that it is in the best interest of the child, the judge can change the orders he or she has previously made.
What counts a change circumstances in these cases? Give us examples.
It varies from case to case, but let's say you had a drug case
Mhm.
and your your reunification services were terminated because you hadn't been testing clean or going to your substance abuse classes. Maybe you can go a period of 2 months where you have tested clean every day. I mean, not every day, but every week. That's a changed circumstance. Maybe for 3 months you've tested clean. Now you've shown the judge that you are testing clean.
I've known
Mhm.
parents that tested clean for a year.
And what does that have to do with the question?
No,
I'm just giving an example
right.
of what a changed circumstances could be. And my example was the person hadn't been testing clean, and now they are. In your case, where they've been testing clean for a year,
Mhm.
maybe they need to show something else, like consistent visitation or finishing their domestic violence class or internalizing and progressing in their individual counseling.
Okay. So what kind of proof should a parent submit with a 388 petition?
Certificates, progress letters from the therapist or other service providers, character letters, visitation records, photos, anything that builds a case file that shows that you are progressing. I mentioned this the other day. In a case up north, we filed a 388 that was over 200 pages. Now, remember the form itself, the 388 form that you find online, is only 4 pages long. We filed a 388 package that had declarations, it had exhibits like the certificates, like the progress reports, like the letters from the therapist and to other service providers. That was almost 200 plus pages. So those are the things that should be included in your 388. We also included legal points and authorities, which showed the judge why our facts would constitute a change in circumstances and would constitute the best interest of the child.
Makes sense.
And I don't know if you remember this, but I told you within a week of us filing that, the social worker recommended that my client have unmonitored visits.
Okay. Should parents bring witnesses to the 388 hearing?
If it becomes a contested hearing, absolutely. Absolutely, yes.
And they must know this by asking their attorney, right? If it's a contested hearing or not.
Correct. So they should consider bringing the providers, the teachers, the clergy, people who can speak to the parent's progress and their parenting skills. Maybe the person who monitors their visits. Yes, of course, because you will have to prove to the judge that you are a changed person.
Okay, what is a .26 hearing and how does it relate to termination of services? That's a very good question right there, actually.
Okay, a .26 is something called a 366.26 hearing. It is officially called the Selection and Implementation Hearing. That is where the court picks the best permanent plan for the child. And Number one on the hit parade is adoption, the termination of your parental rights. And it is set and scheduled right after the termination of your reunification services. So in California, once your reunification services are terminated, it's set 120 days out.
Wow. Can a 388 be filed to stop or delay the .26 hearing?
Absolutely. That's the primary strategy. And it's one of the last tools that you have left. But it has to be well prepared, well reasoned, and backed by solid evidence. You know, people come to me or they tell me, oh, I filed a 388. And I say, hey, send it over to me. Let me look at it. And most of the time, it's just the form, the 4 pages. And a lot of times, the 4 pages have been filled out incorrectly.
Of course.
Or
No.
inadequately. It's like one of those things, don't try this at home. But everybody thinks they can do it alone.
Can parents appeal the decision to terminate reunification services?
Yes, but as we talked about it earlier, these appeals, they call them writs, must be filed quickly. If the court has to set a 366.26 hearing, you must file that notice of intent to file a writ within a strict deadline. It's usually 7 days, I think. Missing that notice forfeits your appellate rights to challenge the court's termination of your reunification services. And you know what? I want to tell you something. A lot of people don't know that. And
No.
like I said earlier, a lot of attorneys don't know that.
No.
You know, what happens is in a lot of cases, attorneys will file a notice of appeal. And that's the wrong form. And all the court will do will be to dismiss that appeal. And then you've missed the 7 days to file the notice of intent to file a writ. And then you've lost your right to file or to challenge the termination of your reunification services. You and I won't mention any names, but you and I actually know of a person that happened to.
Yes.
And to be honest with you, I think that person had a legitimate appeal for the termination of his reunification services.
Mhm.
His attorney filed a notice of appeal. That was the wrong vehicle. That appeal was dismissed, and then he had, the 7 days had already expired, and he couldn't challenge the termination of his reunification services.
Yeah.
The case went on to the 2-6 hearing, and his rights were terminated. And they were terminated, unfortunately, without him challenging one of the most important things in his case, the termination of his reunification services. So you see how not knowing the right vehicle to use can significantly affect your case.
Yes, it can. And also, the person you're talking about, I know who you're talking about. He hired an attorney from LA, by the way.
Okay.
So it's not like a court-appointed attorney. But anyways, I know the answer to this, but I want everyone else to hear it. Have you won appeals or writ after reunification was terminated?
Yes, our firm has won appeals. We have, won cases where reunification services have been terminated. But, I want to tell you something. It's hard to be in the appellate business, meaning it's hard to win those cases. Don't rely on me or any attorney winning an appeal, all right? Because the percentages are against you. Can it be done? Yeah, it can be. I could win the lottery tonight. What is that, 50 million to 1? I could win it. Okay, but I'm not counting on it. So don't count on winning an appeal. Win your case at the trial court level. Do everything that you need to do to win your case at the trial court. That means coming up with a strategy, implementing the strategy, having the evidence that you need. Don't send your attorney into court with no evidence. I had this discussion the other day. Don't hire me and then expect me to go into evidence and win the case, and you don't have any evidence. I'm as good as you can make me by giving me the evidence that I need to win the case.
Yep.
Do you send a soldier into war without bullets in the rifle?
Nope.
Right. So you got to give the attorney some bullets to work with.
Right. And what is your message to the parents watching this who just got the terrible ruling?
Of the termination of their reunification services?
Yeah.
Don't give up. I've seen parents win after termination of these services, but you have to act fast. You have to document everything and file the right motions or the right appellate notices.
Makes
In
sense.
a lot of cases, especially criminal cases, you can delay things, delay. You can't do that in a CPS case.
No.
As a matter of fact, there are statutes, laws in the CPS realm that say no continuances, no continuances, no continuances. A lot of times I get a call and they tell me, oh, the trial's tomorrow. You can just come in. I've been talking to these people for like 4 months, right? Oh, I'm going to hire you the day before trial. You can just go in and ask for a continuance. Many times I'll show up at the trial and the judge will say, Mr. Davis, if you're not ready to go,
Mm-hmm.
you can't come in on this case.
Yep.
Well, I don't even have the file. How can I be ready to do a trial?
Yep.
Oh, Mr. Davis, when I was doing my criminal case, they got an automatic continuance. Yeah, that was criminal court. Different laws, different interests, different rationales. It's easy to get a continuance in criminal court. It ain't easy to get a continuance in juvenile court. So don't think that an attorney can just easily get a continuance.
My God. You guys, whoever out there is going through this, please give us a call. You can reach Attorney Davis or myself by calling this 888-888-6582. Please call and we will help you as much as we can to get your rights back. I hope you're not too late. But is there such thing as too late when they lose their parental rights? I mean, what I'm saying is it's not too late, right? It's not too late.
Well, everything is relative. Meaning, do you have a chance? Well, you always have a chance. Now, is that a 90% chance or is that a 5% chance? Well, every case is different. And it usually depends on how early or late you call that attorney to help you. How many times have you told or have you heard me have a conversation with someone and I tell them, well, had we started working on the case 6 months ago, I could have done a lot.
I know.
But, you call me 3 days before the hearing, it kind of narrows what I can do on the case. And inevitably they say or they think, well, I was waiting for the social worker to do the right thing. I was waiting for the judge to realize blah, blah, blah.
And it's always like that. Yeah.
I was waiting for my court-appointed attorney to do blah, blah, blah.
Or social worker.
Yeah. I was waiting to finish my drug testing. I was waiting to finish my domestic violence counseling. Everybody's waiting to see that miracle happen. I don't know if you watch professional sports like professional football. The best defense is a good offense. And what I see in a lot of these cases is people are sitting back, just waiting for things to change. Things aren't going to change unless you step up and go on the offensive. These are court cases, all right? They're not, let's be fair to Vince, or let's be fair to the parent. you have to do something. You have to take action.
Okay, can we kind of answer or address a few things, a few questions or a few statements that's written by viewers?
Sure, go ahead.
Tony, Tony said, where is it? I'm going into court with court papers I just received. And Tony also said, I don't have a lawyer. I'm assuming, Tony, this is your first court hearing, right, Davis? I mean,
How would I know?
what I'm saying is usually if she doesn't have a lawyer yet, that means it's the first court hearing. And
Well, if she's in California, that's probably true. But who knows what they do in other states?
true.
Someone from another state, I forgot what state it was, called me the other day and said, "Well, they don't give lawyers in my state," which I was kind of surprised because I thought it was a constitutional thing, but it was a state in the South. I don't want to misstate the state's name, but yeah, she said in my state we don't automatically get free lawyers in CPS cases. I was kind of shocked.
Interesting. Jamie Jamie. Hi, Jamie, my love. Can you do anything to overturn an adoption? Because I lost the Supreme Court appeal and I don't have the money to go to the federal Supreme Court. Much love and a light, Miss Jean. Thank you, Jamie. I love you so much, baby girl.
Well, talking theoretically, the answer is yes. Talking realistically, the answer is probably no.
I know Jamie personally. She's such a good person, such a good mom. So sad. My rights were terminated. I appealed everything from the reunification to adoption and from trial court to superior court to Supreme Court. Wow. What would you tell people that don't have the money to hire an attorney? What about the coaching? Remember the coaching package that you do, which is a lot less than hiring me fully. That can't afford you. I know.
Let me tell you this. That would be great, but I'm going to say this, and I know you're going to disagree with me.
Okay.
Most people that can afford to hire a private attorney have to learn how to work with their court-appointed attorney. That's it.
What?
They have to learn how to work with their court-appointed attorney.
What the?
You can't afford an attorney. So what are you going to do? You're going to just complain? You're going to, talk about what the attorney doesn't do or, should do? I told this to somebody the other day, and I want you to listen to this carefully. Everyone that gets a court-appointed attorney expects that they're getting Johnny Cochran. That's what they expect. That's not what the law says they get. The law says they get a warm body that's generally competent in this area of law. Now, that's a far cry from Johnny Cochran. So when they get just the generally competent person, the warm body, they're disappointed that they're not standing on the counsel table stomping their feet. Now, that disappointment comes across in their dealings with that court-appointed attorney.
Right.
Court-appointed attorneys are human beings.
Right.
If you're not, getting along and showing, appreciation, in the back of their mind, maybe they're not giving you the love you think you should be getting. So I should probably do a course on how to get along with your court-appointed attorney, how to get the most out of your court-appointed attorney. I've seen people turn around their relationship with their court-appointed attorney and do very well. I've seen people not get along with their court-appointed attorney and crash and burn. Crash and burn. You know what I mean, Miss G?
No, I don't.
That happened to you.
No, not at all. What I'm saying to you is that you're saying this to people who are listening, and it's not true, because no matter what you do
Miss
for the
J, how many cases have you done?
it's not that, is the court
Tell
appointed.
me. Tell me how many cases you've done, because I've done thousands. Okay.
I'm not going to debate with you.
30 years ago, 30 years ago, I was a court-appointed attorney. 35 years ago, I was a
Okay, well, that
court-appointed
was
attorney.
35 years ago. Right now,
But I see it every day when I go to court. I see
oh,
court-appointed attorneys all the time doing cases.
all right.
I talk to them. I listen to what they say. I talk to people all the time who have court-appointed attorneys. Look, if you can't hire an attorney privately, the only thing you have is your court-appointed attorney. You cannot do the case by yourself. That's the bottom line. So you have two choices. Get along with your court-appointed attorney or hire a private attorney. That's it.
Then do a segment on how to get along with your court-appointed attorney.
I've been thinking about doing a course on how to get along with your court-appointed attorney.
I think is best, because they come out very strong and they're so disrespectful to parents. I listened to an audio of a court-appointed attorney and a mother, and the way he interacts with the mom is so horrible. He called her stupid. He told her horrible things to trigger her or something like that. And the mother was remaining cool. That's in New York, by the way. The mother remained cool, and she asked him, why are you speaking to me like that? You don't even know me. He said, all these allegations, and you're never going to see your child, but you're never going to see your kid again. So how do you tell people to handle that? Is there a strategy to handle stupid court-appointed attorneys who are bankrupt from themselves? I mean,
yeah, there is.
All
There
right.
definitely is.
I suggest,
It has more to do with your ability to deal with people than it does with the law.
you need to have the ability to deal with demonic people. Right. So I think you should do that, Vincent. Honestly, it's going to help a lot of parents, because some of those court-appointed attorneys are horrible people. Horrible.
And this is the other thing. I have a video, one or two videos on the YouTube channel that tell you how to get a new court-appointed attorney if you don't like the one you have. And I was looking at this is about a couple months ago. I was looking at the stats and the views on different videos that we have. That video is probably you would think that would be one of the highest viewed videos of all time. It's not. Here I am telling you, if you don't like your court-appointed attorney, how you get a new court-appointed attorney. For whatever reason, it's not a high-ranked video.
So okay, so let's go to Tony, because this is concerning me. So I'm right. Today's her first hearing. She said, as we're talking and texting, this is my new appointed lawyer, just now calls me. Can I request to postpone of this modification that CPS wants? My son is in the ER. They refuse to let me see him, talk to him. Are trying to put him with grandparents or psychiatric facility.
Was there a question in there?
I thought there was, but I guess I missed that part. Okay, Dorothy, what if I was never given reunification hearing nor offered anything that has to be done for reunification of my child with me?
Well, there are some cases where the court orders that you not be given reunification services. There are some cases like that. But if the court ordered that you were to get reunification services and you weren't given them, it's up to you and your attorney to challenge that at every 6-month hearing. And every 6-month hearing where the court finds that no reunification services or reasonable reunification services were not given, you're usually given more reunification services until they give you the appropriate amount of reunification services, reasonable services. Now, the problem is that you and your attorney have to bring these issues up.
Right.
Now, if your attorney doesn't bring them up, you're going to have to tell the attorney to bring them up. If you don't know to bring that up to your attorney, you're going to have to learn that. Because as I've told you, the rule of law in our country, unfortunately, is ignorance is no excuse. You know, that's one of the reasons why I did that YouTube channel, or I do the YouTube channels, to try to tell people, you know, generally what the issues are in these cases, because most people don't know. You know, I don't know if it was you, Ms. G, or I was telling somebody. No, I was telling a new client this. You know, when I first found out about these cases, CPS cases, I was working at a law firm. And another lawyer that I work with was going to do CPS or juvenile dependency cases as a court-appointed attorney. Number one, I never heard of court-appointed attorneys. And I had already been a lawyer 3 years. I'm like, what's that? Number two, he told me, oh, that juvenile dependency is where they take away kids from parents. And I'm like, Mike, that's unconstitutional. Unconstitutional. That's impossible. They can't take kids from parents. I'm already a lawyer, 3 years. I'd never heard of such a thing. So I'm not surprised that this is all brand new to people, to parents. I didn't know. How are they going to know? Well, you know what, the law doesn't care. Ignorance is no excuse.
Christina said, my court appointed would not file a 388. Reason it was important. I had a home and I had statements against lies, and I still have that paper. He said judge would not allow it. So basically the judge would not allow to file a 388. How is that possible? If you told me that a 388, once it's filed, you have to have a hearing on that, whether the judge approves of it or not, right?
No.
Okay,
if you file a 388, the judge gets to decide right from the beginning whether to grant you what they call a prima facie hearing, or to just deny it outright. If it's denied outright, you have to appeal it. If you're granted a prima facie hearing, that's where a hearing is to decide if you get an evidentiary hearing. If the judge decides you don't get an evidentiary hearing, you can appeal that. If the judge says, okay, we'll give you an evidentiary hearing, Davis, and you go to the evidentiary hearing and you win, you get what you asked for in the 388. If you lose, you got to appeal that. Now notice, you could go file your 388, the judge could grant it and give you a prima facie. You go to the prima facie, the judge could grant it and get an evidentiary hearing. You go to the evidentiary hearing and you could lose. So you could win 2 of the 3 and still lose. It's kind of a step program. It's like you're jumping through hoops. But you got to keep jumping because they got your kids.
Hey, Vincent, I have a question. And this really is really pissing me off. A lot of judges, I've noticed, they, you know how they have to have a background check for foster homes and all that stuff. There's a lot of judges who, CPS workers who place children in sex offenders' homes. Meaning,
no, they're not. No, they're not. It's not true. There's not a lot. Has it ever happened? Yes, I believe that it has.
So why would you say it's not true?
Because I've been on thousands of cases. I said it can happen, and I believe that it probably has happened, but it's not a lot.
Hope said, I feel like the judges working with CPS in our case and our appointed lawyer are also on CPS side.
Okay,
I
that's
agree.
it. That's easy to feel that way. Number one, as I told Ms. G yesterday and today, by law, the judge has to accept and consider the CPS report. That's not because he or she wants to. They must accept into evidence and consider the social worker report. So if you got the feeling the judge was considering the social worker report, you got the right feeling, because that's the law. Okay, you stop on red, you go on green. That's the law. Now, if you think the law should be different, okay, get a group of people together in your state and change it. There's a way to do that. Costs a lot of money, costs a lot of work, it's a lot of time, but there's a way to change laws. If you're not going to do that, you better get a good attorney and fight the social worker. A long time ago, I wrote a book, The Secret: How to Fight CPS and Win. That title was very specific. It wasn't some random title. You got to fight these people. You got to fight. And there is a way to fight. The laws are, in my opinion, the laws are kind of stacked against you in favor of protecting the child. What kind of law is that one side of the lawsuit gets to write a report full of hearsay, full of multiple hearsay, and the law says, oh, judge, you have to accept that into evidence and you got to consider it. Like, what? You don't get to write a report that contains hearsay and multiple hearsay, and the judge has to consider it. How is that fair? Supreme Court of California, and probably most states, have said, oh, that's fair. That's fair. Now, I could cry about it. And when it first happened, in the early 90s, I did cry about it. Like, how is that fair?
It's not fair. It's not right.
And I cried about it. But you know what I realized? Crying about it didn't change anything. So I figured out, if they're going to stack the decks against me, how can I win? There's still a way to win. That's what you got to realize. Still a way to win.
Okay. Hope asked, what is a 388? But you already covered this earlier in the video. I don't know if you want to explain it again or you want her to watch the video.
Hope, if you're in California, 388 refers to the Welfare and Institutions Code, Section 388. If you Google it, it'll print out the entire statute. You can read it. Basically, it's a get out of jail free card for the parent to get back in the game when they're out of the game.
And also for relatives also too.
Yeah, it can be used for many things.
And there was somebody here talking about grandparents' rights. Yes, grandparents do have rights. Would like to elaborate on that, or would that be on another show tomorrow?
Well, we can do it at another time, but let me just say this. Grandparents have rights, but they're limited, and they're really not what you think they are. Okay? Sometimes you say, well, I have rights. Well, how narrow or how expanded are those rights? And they're not as expanded as you think.
Okay. All right. I guess we're done here.
Oh, wow. Look what time it is. Yeah. Well, thank you, Ms. G, for joining me. Thank you, everybody, for watching. We'll be on tomorrow at 6. Well, wait a minute. Tomorrow is Saturday. We might be on a later or even earlier edition tomorrow. But we'll see. All right, everyone. I want to thank everyone for watching. If you have any questions, get them written down so you can come and post them in our comment section. Ms. G, thank you very much for getting up early and joining me this morning.
You're welcome.
And we'll see everybody tomorrow on our office hours. Have a good day.
Bye-bye.
And from there, he just actually got my case eliminated out of that courtroom in about 3 months. So I'm here to advertise Mr. Davis and to tell the parents that he's on top of the food chain as far as lawyers, and I totally recommend Mr. Davis to any family out there. Thank you.